A very good morning
Good morning, sir.
to you, Karnal Singh ji, and to all the viewers. I am C. Paul Singh, former IG Punjab and ex-chief of Rapid Action Force, Government of India. I am here with you this morning as the president of NISSMAT. NISSMAT is a think tank organization and it conducts discussions, deliberations, and webinars with scholars and reputed social and political personalities. The ex-defense services officers, ex-bureaucrats, and eminent police officers interact in these sessions. Let me introduce the eminent speaker of today. Today morning, we have a very well-known and retired police officer, Shri Karnal Singh, who has served with distinction in various important positions. He's a postgraduate in computer sciences and an MBA in finance. Shri Karnal Singh is a retired IPS officer who was conferred the President Police Medal, as well as President Police Medal for Distinguished Service, as well as Police Medal for Meritorious Services. He is superannuated in 2018 from the Enforcement Directorate. He computerized the functioning of Delhi police and also introduced technology in the Enforcement Directorate by establishing 6 cyber labs in the country. Shri Karnal Singh also represented India in various foreign delegations. I must tell you that he is not only an eminent and erudite scholar and speaker, he was also awarded the distinction of being the best sportsman and the best athlete awards in the National Police Academy. In the Enforcement Directorate, he supervised investigations in important money laundering cases. He is the author of a book titled Butler House, an encounter that shook the nation at that time. He was also responsible for overseeing a number of bomb blast cases in Delhi, including the investigation of Upahar cinema tragedy. After the introduction of the speaker, let me now say a few words about the subject of today's podcast. Under PMLA, Prevention of Money Laundering Act, what is Money Laundering Act? Now, Money Laundering Act is defined as any process, any activity which is connected with the proceeds of crime, including its concealment, not only concealment, in fact, including its acquisition, including its possession, including projection, this money as untainted money, that also come under PMLA. The unique feature of PMLA is that it does not operate in isolation. It is intrinsically linked to other scheduled offenses listed under this act. The scheduled offenses relate to serious crimes under various legislations and acts such as IPC, then the Narcotic Drugs and Psychotropic Substances Act, Prevention of Corruption Act, Arms Act, etc. Now, for example, cases of corruption, cases of bribery, cases of fraud, cases of forgery, cases of arms trafficking, cases relating to terrorism financing and narcotics are treated as predicate offenses under the Act. When such offenses generate illicit proceeds of money, the Prevention of Money Laundering Act comes into play. In fact, I'll say that the Enforcement Directorate and the investigations are an arm of India's fight against organized crime and corruption. The Enforcement Directorate faces multiple challenges, which Shri Karnal Singh will elaborate. I'll just touch some points as an introduction. For example, tracing the money trail becomes extremely difficult when funds move rapidly across the borders. Challenges also faced in volume of cases vis-a-vis the number of officers available with the Enforcement Directorate. The complicated judicial process, you see, also adds to the problems which are faced by the ED in such cases. Then the convictions under PMLA are comparatively low due to lengthy trials. Now, challenges in admissibility of evidence and frequent legal appeals also cause problems. I will like to mention in particular the difficulties faced by the Enforcement Directorate in handling cases involving global terrorists. Since I have been dealing with terrorism a lot, so I'd like to mention a few words. Terrorist network actually use very sophisticated hawala and underground channels. Then there's a rapid movement of the funds, leaving behind very little formal evidence. With these words, which I feel basically are the challenges, there were many more challenges which Shri Karnal Singh might have faced during his tenure in the Enforcement Directorate. I now request Shri Karnal Singh ji to elaborate on the subjects of today's podcast. That is, challenges faced by ED in combating money laundering. He will give you some practical instances and elaborate. Karnal Sahab, it is up to you now. Go ahead.
Okay. Thank you, sir. See, the first, when I was Director ED, after 2-3 months, I got a call from Shri Nripendra Mishra ji, who was the Principal Secretary to Prime Minister, saying that one of the ministers in the government, in the cabinet meeting, was discussing about the Enforcement Directorate, that ED is not performing well. They are not handling the case properly. So he asked me what I have to say. I said, sir, he's right. So he was a bit taken aback. Instead of defending my unit, I am saying the unit is not performing well. So then he asked, what is the reason? Sir, you just mentioned about the manpower. So I told him my sanctioned strength of the Enforcement Directorate is 2068. And I'm talking about this in 2015. And my present strength is only 531. What do you expect? So he said, then what is the solution? So I said, sir, there are two things which I want to submit to you. The one is that there was a Vineet Narayan judgment of Supreme Court in which the Supreme Court said that to attract talent in the CBI and Enforcement Directorate, there should be incentive in pay.
Oh,
So CBI got that incentive, but ED has not got that incentive. So I'd request that you give us the equivalent incentive to ED also. That was number one. Number two, I said that our selection from joint director and above is through CVC, which comes faster. But the selection deputy director and below for deputation is coming through UPSC. And who in a year gives 8-9 people only to us. Now in Central Bureau of Investigation, the selection before the DSP and below, which are of the equivalent rank in ED, one can say, is done through DOPT. So why in our case it should not be done through DOPT? So he asked me to send a proposal. So proposal was sent. After much struggle, of course, in the expenditure part of the revenue department of the finance ministry, ultimately both of them were approved and the manpower started increasing. So that was the first hurdle we could cross. Today, all the posts have been filled.
oh, good.
And Enforcement Directorate has given a proposal for increasing the strength of the ED. Secondly, sir, at that time I faced the situation like we collect a lot of digital evidences. Now these digital evidences we were sending to CFSL for examination and for giving us feedback. Now strangely, we were getting the report somewhere between 6 months to 2 years. Now this is a very long period of response. If we are investigating something, some digital evidences, and if we have to interrogate people, and if we don't have analysis, then it becomes very difficult to analyze. Therefore, I sent the proposal to the government for establishing in-house cyber labs.
Oh, so CFL otherwise deals with all states also, I think, is it?
They deal with all states also, so they perhaps is overloaded. So then we were able to get analysis done within a day, and it was very useful, so that the pace of investigation is faster. Now, sir, you also mentioned about conviction rate, and this is being mentioned almost everywhere that the ED conviction rate is very, very poor. Now, as a police officer, sir, you are aware conviction rate is calculated based on the number of cases decided.
Okay, not on the number of cases investigated.
Not the number of cases investigated or number of cases and for trial. Now, this calculation which is being done at various places is number of cases resulted into conviction divided by number of cases sent for trial.
Oh,
It's a wrong calculation. Now, sir, we had once this our annual day where Revenue Secretary himself, who was in the finance ministry, in front of the chief guest and the press, he raised the same issue. He said that ED is not doing well, their conviction rate is 0. So thereafter, after he finished, I got up. I told that I should not have been speaking after the Revenue Secretary, but I must clarify something because the press is sitting here, other people are sitting here, so they must know the facts. I said, I agree there is no conviction, but there is no acquittal either. And then I mentioned that our accused are generally high-profile people who are able to get the delay in the investigation by approaching the court, and they get orders on the drop of the coin. So it is not easy investigation when you are doing investigation against the politicians, against the people who are moneyed people who are able to get the best advocates in the country approaching the courts. So, of course, the Revenue Secretary later on told me that he was not aware. Sir, the latest annual report which ED has brought out mentions that cases have been decided till now, till the report, and out of that, 19 cases has resulted into conviction.
My goodness.
So it is a 19 divided by 23 multiplied by 100. So conviction rate is more than 80%, sir. So that is one area where I keep explaining people at various forums, even on TV, sometimes this issue is raised. And when I'm sitting there, I explain what is the conviction rate. And many people don't understand. As a police officer, sir, you will understand what is the meaning of conviction rate.
Okay.
Then, sir, issue comes because these people who are involved in money laundering, not only do money laundering within the country, they do money laundering involving various countries. For example, sir, we take this Augusta Westland case, where the bribe started from Italy. It went to Mauritius. From Mauritius, sir, one part came to India. But the most of the part of this, I should say more than 90%, went to Dubai. From Dubai, it was mixed up in various other accounts. Then a part sent to Switzerland, part sent to Singapore. Now, interestingly, in Mauritius, the bank account, bank which was existing at that time, Mauritius had the fly-by-night banks also. So there is a bank today, tomorrow there is no bank.
My goodness.
And there is no record available. So this was one of the cases where the bank was a fly-by-night bank. So we could not get the record from the bank. We could construct only the money started from Italy, where it had gone, and then connecting dots in Dubai and other places. Now, in the foreign country, we send letter of request or letter rogatory to our courts. Now, sir, whether it is a letter rogatory or whether it's an extradition process for any criminal or accused, it is a political cum judicial process. It is never a pure judicial process. That country examines us whether this demand is genuine or not, whether there is a concept of dual criminality. That is, it should be a crime in India and it should be a crime in another country also. Only then they will execute LR or they will execute the extradition request. So first it is examined bureaucratically whether they should execute it. And if they decide to execute it, they go to the court to get the orders. And in most of the countries, court give opportunity to other party. And the process goes to, if the judicial process starts, it goes till Supreme Court, sir, till their Supreme Court. And if we take, for example, sir, Vijay Mallya case, for example, now even the Supreme Court of that country decided that he has to be extradited and issued the order. Now, only part remaining was that the Home Secretary of the UK to issue orders of his extradition. So it was only executive order. Judicial process is over. Now, sir, 4 or 5 years have passed. I should say it is almost 8 years have passed, sir. They are not issuing orders. Unofficially, we know that he has given an application for asylum and we have nothing more to listen from them.
Oh, goodness.
So this hurdle comes. Sir, you have also talked about the intelligence sharing between the countries, because this is very, very important. So there is Egmont Group, which is internationally placed, and it has the financial intelligence units of all the countries as the members. 155 members are there. India is also a member of the Egmont Group.
Yeah.
Now they share intelligence with each other. Sometimes we get very good intelligence. Of course, there is a bar that this information, being intelligence, cannot be used as a piece of evidence. We have to work on it. So this is one way where there's international coordination is there. Second is the Financial Action Task Force. And the Financial Action Task Force basically formulate the policies about the money laundering and terror financing. They have got, sir, 40 recommendations which should be implemented. Laws should be made according to them.
1 minute. This task force is a national or international?
Sir, it is international. It was started in 1989.
Oh, I see.
And it has today 39 members. 39 out of that, 37 are country. 2 are the groups. But sir, there is a mechanism to involve all the countries. So they have 9 other groups like FATF. We call them FATF style regional bodies.
I see.
Now these 9 groups, like India is also a member of 2 such groups. One is Asia Pacific group and another is the Eurasia group. So around 180 countries of the world are member of one of other of these groups. So though FATF has a minimum like 39 members only, but one can say all 180 countries which are members of various FATF style bodies, they indirectly participate in FATF. So FATF formulate the policies, gives the recommendation to the countries, and also has, apart from the 40 recommendations, it has 11 outcomes. 11 outcomes are the effectiveness. Like, sir, Pakistan, what it was doing, it has formulated the laws which were required to be made against money laundering and terror financing. But it was not implementing them properly.
Oh, I see.
So, though Pakistan is not member of FATF directly, it is member of Asia Pacific group. But the report of, there is a process of mutual evaluation. Each country undergoes the process of mutual evaluation after around 10 years or so. And mutual evaluation is done by the representative of different countries. So Pakistan mutual evaluation, which was got done by Asia Pacific group, was produced before the FATF. There we raised the objection that Pakistan is not implementing the laws.
I see.
So what was that, sir? The United Nations Security Council Resolution 1267 is there, which says that the terror financing of Al-Qaeda and related entities and other entities, if it is declared by United Nations to be banned, then their fund should be seized in any of these countries. So this Lashkar-e-Taiba has a charity organization, which is called Jamatul Dawa, sir.
That's the face, sort of, face group.
Front organization, one can say.
Front
So the Jamatul Dawa, now they turned into also, when the ban was laid down by the United Nations Security Council, then they changed, they put another organization, Falah-e-Insaniyat. Now they are basically on front, they are charity organizations, they have hospitals, they have schools, but they fund the Lashkar-e-Taiba also, sir. So Pakistan had not seized their funds. So we raised this issue. I was there in the FATF meeting that time. We raised the issue against Pakistan. And Pakistan that time was put on the grey list. It is basically, sir, naming and shaming, putting in grey list, and there is another serious list, black list. If some country is put in the grey list, then for internationally it is considered to be a rogue country. And then the financial transactions with such country becomes difficult for the other countries also. So these countries suffer economically. And therefore they take care of that. They have to implement those things. But till the time mutual evaluation is not done, they are free to do whatever they are doing. Once mutual evaluation is there, they are under some sort of problems vis-a-vis the international community. But international cooperation is not very, very forthcoming, sir. It takes huge time. Sometimes we don't get information. To this extent, in one case, there was a Hassan Ali. Hassan Ali case was in the Supreme Court, sir. And this SIT on black money was formed on that case. This Hassan Ali is supposed to have, sir, we are not sure, around 60,000 crore in Swiss banks.
Oh, goodness.
And what he did is, and in one of the one of the transactions, he wanted to purchase a hotel there. And then a meeting was held in the bank of the purchaser who was from the Switzerland and of this Hassan Ali. And bank told the other party that he has sufficient funds in bank. But sir, when we asked the information, we were not getting any information.
Oh, I see.
And then what he did is, sir, after he siphoned off money from this bank to some other bank, then we got information from one bank. So then again, letter of regulatory one sent. It's almost when I joined ED as director, the case was even at that time, and it is pending even now. Though Hassan Ali has died by now, so the information has not come still from there.
So far.
So that is a problem of international cooperation, which you mentioned rightly, sir. And there are other issues, sir, in the challenges which are faced. Like, for example, we get, when we search at certain places, there are digital evidences which may be of different format. Even the bank's information comes in the different formats. One bank has one format, another bank has another format. And there are much information which is on paper, which is not even digitized. Now, how to collate all this information and put in the common format?
I see.
In India, we do not have such tools. Though in the foreign country like USA, they have made such tools, very costly tools, they are there. Then, lack of analytical tools, sir. In India, we have not produced even a single analytical tool to do financial analysis.
I see.
They are all procured from the foreign country.
I see.
Except SFIO, Serious Fraud Investigation Office, who have got some tools in their lab. No other organization, whether it is CBI or any other organization, has those tools. So that is another area. Day before yesterday, I was in Rashtriya Raksha University. I told them, why don't you start this project? So that the country gets benefited out of such projects. Then, sir, there are concept of shell companies.
Yeah, shell company.
Which are used mostly in all the money laundering cases. And what happens is, sir, when there are interbank transactions, suppose there is a transaction between State Bank of India and another account is, suppose, in HFDC Bank, then these interbank transactions are recorded by the RBI. So RBI has a record of interbank transactions.
Yeah.
But intra-bank transactions, RBI doesn't have the record. If the one branch of the State Bank of India sends to another State Bank of India, then the RBI doesn't have got the record. Now, to check the shell companies, we require end-to-end transactions. If we do end-to-end transactions, we can find out.
One minute. Why it's within the government, I think. It's supposing instead of State Bank, it is said to the Reserve Bank is given duty. Then why the government of India it cannot do?
Sir, Sir, long back, I had given a proposal of a search engine to be made in the RBI.
Yes, sir. That's what I'm saying.
And it was approved by PMO. A meeting was called in the finance ministry. RBI officers were called. Everybody was called. But sir, till date, it has not been made.
Oh, my goodness. This is within our country, outside of your. One other point before we proceed further.
Right, sir.
You very beautifully mentioned about the front organizations in the case of the Pakistan operated AIM. But what about this front organization in certain, certain ideologically, not only I'm saying ideologically, of course, even the Islamic group is ideologically, certain other ideologically operating. I'm talking not in terms of directly leftists or rightists or anything, any ideologically motivated group. They also operate through the front organization where they are facing problem.
Sir, there are two things. One is when we talk about terrorist-related issues, they have front organizations. But when we talk of these ideologically,
Yeah.
they are generally getting FCRA.
I see.
And that's why the government has made the FCRA a bit strict. There is amendment in law. Like, for example, before giving permission for FCRA, government does the checks from where the money is coming. And all money can come only to one account in the State Bank of India. One cannot get any account. And you cannot mix Indian money into that money. And the purpose keeps on monitoring by the government. A number of organizations were taking money from abroad and working on their ideology. And sometimes they were opposing our projects.
Oh,
So that has been taken care of by the government of India now.
I see.
Through FC.
So terrorist organizations becoming a lot more difficult.
Terrorist organizations, like, sir, let me, about terrorist organization, I explain, sir. For example, Lashkar I talked in Pakistan. I'm just talking first about the Pakistan, sir. Then Jaish-e-Mohammed also has a Al-Rahmat Trust. It is a front organization which collects that. And sir, there is one International Islamic Relief Organization, which is today known as International Organization for Relief, Welfare and Development. It collects fund, which in Islam there is a concept of zakat, where they donate a part of their income as a gesture for helping the poor, helping the people who are not having enough resources. So what they do is that they give it to these organizations. The International Islamic Relief Organization was providing funds to Al-Qaeda.
Sir, I mean, indirectly, even this Islamic organizations are ideological motivated, indirectly or directly, you may say.
Right.
When I referred, I was saying about the mouse working in certain areas. And we are dealing with them, no doubt, effectively now to a great extent through our armed battalions and all. But I was saying about funding of such organization. Let us say, CPI-ML has been at one time said that they have been funding the Maoist group, which are working in Chhattisgarh, which are working in your area where we have now started having such a song, we'll wipe it out and all. But I was just thinking that these are also ideologically motivated. Is there any restriction or something which we can control? As well as Islamic organization, I get your point that they have Central Front organization. The problem is inter-country also. In this case, I'm talking about the leftist terrorist group.
Sir, if you see Naxals, most of the money is coming through extortion. Through extortion.
Extortion. Oh, that I know, local extortion.
And the protection money.
Yeah.
So what they do is, if any government gives any contract to anybody, so they take money from him, whether he's a government contractor or whatever he is.
Oh.
Even the betel leaves, when they are transported from their area, they collect money even from the farmers, from the lot of money they do it. Previously, they were found to be connected through Manipur side to China. That was also there.
Oh.
But they do not have any direct charity organization in the
country. I see. That's what I want to know. So that's all I said. Protection money, etc. We know that organization which have got certain rights there are working for. So even development, say anything, road building, etc. Those organizations do pay protection money to the next group. Otherwise, they'll be eliminated and all. You're right. That means otherwise there's no such, organization as such fundamental. When it is a fundamental organization like Islamic, they have got foreign money. But in this case, it's local groups.
Local also, sir, but there are certain urban Naxals, which we say, who are sympathizers to Naxalism.
Yeah.
And they provide support otherwise. They provide support, propaganda support. They provide support like giving shelters, provide supports in legal battles. So that is also there, sir.
Yeah. So proceed further. I was just asking this question in between. I will not interrupt your thought process. Go ahead, sir. You're talking about other hurdles which you're feeling.
So the another area is when you talk of the conviction rate or speedy trial. Now, one thing has come positively in this BNSS, Bharatiya Nagarik Suraksha Sanhita, which has replaced CRPC. So there is a timeline now given. And for example, the cognizance of the case has to be taken within 14 days. Now, previously, discharge applications were filed by one accused will file once. Once it is rejected, then second accused will file. Now, in the new setup, all the accused have to file at one go. They cannot file one after another. Then a trial in absentia is also a concept now. If 90 days of the person doesn't appear in the court, then trial can start in his absentia. The judgment, if the court has reserved the judgment, then it has to pass the judgment within 30 days. Previously, there was no time limit. That is one, the positive step has come, but it has to be seen how it will be implemented, because the advocates, they are master in delaying the cases, sir.
They're masters.
Then, sir, another problem comes in the investigation itself. Multiple agencies investigation. Like the same, ED takes we have the schedule offense, and then we have the money laundering offense. So at least when the ED comes into play, at least there are two agencies. One is the predicate investigating agency, and another is the Enforcement Directorate. Like in one may be CBI, one may be ED. But sir, in some cases, there could be SFIO also coming into picture. The income tax may be coming into picture. And if any agency conducts raid, collects evidence, the sharing becomes very difficult.
Oh.
So there is a lack of coordination between the agencies within the country itself. And they don't share what they are doing with each other. So I had given a proposal, sir, about that evidences, there should be nodal agency for evidences also. Like if any agency collects the evidence, it has to deposit there. They can put a bar that they should not share with so-and-so, clear-cut bar. But otherwise, it should be available to all the investigating agencies. And that agency will be produced in the courts whenever it is required. Second is that when these different agencies work, like CBI is working, ED is working, they are sometimes work for cross purposes. So I had also suggested a concept of nodal agency which exists in USA, or lead agencies, I should say. One of the agency will take a lead and others will follow that. Now this lead agency is to be decided by somebody in the government. So this proposal was accepted, and NSA was made the lead officer who will decide which agency will lead, but somehow it has not become functional till today. Then, sir, investigation by ED also has sometimes issues. What they start doing is, instead of investigating only the proceeds of crime, they start investigating the whole business.
Oh.
And with the result, many business gets failed because of the ED actions. So that means that there has to be some controlling factor about the investigation process. Then, sir, section 50, wherein the person is called for the interrogation or questioning. Now in CRPC, there were two different provisions, one for a witness and one for an accused. Like witness will be called under 160 CRPC, and accused will be called under section 41 CRPC.
Correct.
But here there is only one section 50 for both. The Constitution Article 20, Part 3 provides protection to a person to be silent about his criminal activities. But Section 50 doesn't say you are interrogating the accused.
Oh.
So the person is bound to tell the truth. So it violates the article. The courts are not very clear about how to deal with this particular situation. Now, ED sometimes arrests people based on he is not cooperating. He is not telling the truth. But the question is, what is the truth? What ED officer feels is the truth? What the person who is appearing is telling the truth? So that is also a problem area, I should say. Then there's a lot of discretion available. Discretion, why discretion is required, sir, at these stages. For PMLA, only ED can investigate the cases. 2068 officers. You cannot take up all the cases in the country, all the predicate offences in the country. So you take up some selected cases. That means there is a choice, which case to be taken up, which case not to be taken up. And this discretion, to control this discretion, the ED requires a manual.
Yeah.
Like CBI has a manual. Sir, I have got the manual drafted by appointing some retired CBI officers. But that manual was not finalized till my time, but it has not seen the daylight till today. But if we have to improve the functioning of the ED, train the ED officials to know their limits and their boundaries, we require a proper manual for Enforcement Directorate. That is another area, sir, which I feel one can say it is a challenge, but it is also the control on that. Then, sir, there is the issue of manpower and technology, which I touched upon previously also. ED certainly is a short of manpower today, sir. Not only short of manpower, the manpower requires to be trained in financial analysis. So this is very important, and technological capacity, which is very, very important and which is lacking. Then there are various other challenges also, sir.
Yeah.
One is a judicial challenge, because in many cases, there is a judicial intervention, rightly or wrongly, and not to proceed further in the case, in the investigation. Like that, they are there. Then the delay in trial, that is also a challenge. Then there are pure political and bureaucratic challenges also, sir. Sometimes the people try to interfere through politicians. Now it depends upon the officer, sir, how he proceeds thereafter. Bureaucratic challenges comes in form of transfer. Who will come in ED and who will not come in ED? Suppose the officer is doing very well and he's transferred out from the ED. So that is also some challenge. I talked about some delay in foreign evidences. One more thing ED does is, sir, makes large number of accused.
Large number of?
Accused. Like in a case, there will be 200 accused.
Accused?
Yes. So some people could have been made witness, which would have strengthened the case. Now 200 accused, 300 accused, we know as a police officer, what will happen?
Impossible.
So that case will linger on for a longer period, sir. So this is what I had to say, sir.
I'll just not interfere much, but I mean, I have interfered here and there and asked some questions in your thought process. I'll only ask one or two clarification. Any judicial reforms, immediate, I'm not saying long drawn out judicial reform in our country, which is very difficult, because you have explained at length how it becomes inter-country problems, how it becomes number of accused coming, how the bureaucratic changes. and all, this becomes a problem. I mean, you have given at length beautifully what are the problems faced by the ED. But as a very seasoned and eminent police officer, do you think that any judicial reforms in our country, I mean, not elaborate judicial reform, which immediately can be probably implemented, any set of judicial reform as far as the Enforcement Directorate is concerned, not that the such judicial reform, if they impinge on the legal powers of the states, etc., that will become difficult. Any judicial reform which are easily possible to be undertaken so that the working of the ED particularly becomes a little easier. It is a very difficult process, as you have said, but little easier. Such judicial reform, have you any in mind?
Sir, one, I should say legal reform, in the sense that what is happening today is, sir, this the PMLA, there is an overall supervision, one can say, is of the adjudicating authority. Because everything one does in the ED reports to adjudicating authority. For example, attachment is done, reason to believe that this property is involved in the proceeds of crime is to be sent in a seal cover to the adjudicating authority, not to the court.
Oh, I see. That's it. That's it.
In a criminal offense, it is a criminal court which sees the overall what is happening.
That's right. That's right.
All these reports, instead of going to the adjudicating authority, should go to the criminal court, which has to try the case.
Oh, yes.
Because the criminal court is not aware of the case unless a person is arrested.
I agree. So it can be in the civil court.
The adjudicating authority is a civil court, basically, sir. But the criminal court which decides the case, before whom the accused is produced. Now, when accused is arrested, the reason to believe again sent to the adjudicating authority, not to the criminal court, which will give bail or which will not give bail,
bail or not,
which will decide the remand of the case.
And I think this should be, as you rightly said, this is a process which can probably be done without much difficulty in our own country, as you said, because in the case of such cases, which do not require a criminal response or something, that's a different thing. But as far as the civil court jurisdiction is there, then at least some certain things can be decided by the civil court straightway in such cases. You are right. Anything else you'd like to elaborate, sir?
No, sir. Thank you. Thank you.
I like to thank you very much, very, very much, dear Shri Karnal Singh ji, for having, given some time to us to elaborate on this very important subject. Many reasons you have already indicated, like judicial challenges, admissibility of foreign evidence, then which weaken the ED's functioning and cases in the court of law. You have also said about the limited power, manpower, and the number of cases. You have also talked and left about the technological capacities available, and a number of suggestions which you have made have been implemented. I mean, it was a great pleasure to hear from you, and it was really, really practical. In certain cases, we people who have been in the police may be not knowing that much, because we always say, what is happening, because we are not functioning in that particular area. Therefore, we are not aware of such things. But it was a beautiful, very elaborate, critical, as well as crystal clear analysis. We thank you for having spared your time to come here, and look forward to such interaction with you in future also. Thank you so much. Thank you so much.
Thank you, sir.
I'm grateful. Thank you. Thank you.